Hi everyone, my name is Sophie Taylor. I'm a lawyer at the Mental Health Law Centre and here to talk to you about trauma-informed lawyering. Just as a general overview, I like to think that trauma-informed lawyering is the equivalent of having like a good bedside manner for a doctor, but for a lawyer instead. And really it's about engaging with the client in a way that's not going to re-traumatize them and understanding the way that trauma can impact on how a client is interacting with you, including their recollection of events and how you're going to get instructions and adapting to that so that you can get the best results for your client. Part one is interacting with clients. I often find it useful to have a support worker come into the interview with me when I'm interviewing a client. So that person could be a paid support worker or it could be a family member. Of course, it's important that you would discuss with the client first that they're okay with that person being present and that you have their consent and that they understand how that will impact on the client lawyer privilege. But I do think that it can be helpful to have that support worker there because they can, well, first they're just supporting the client, so the client might feel less anxious, and also they might be able to help jog the client's memory about something, and you also might be able to get some information from that person, perhaps even prior to the interview, and then that reduces the need for the client to have to retell the story, which often when clients are retelling a story, it's re-traumatizing them. You do need to be careful though that support worker knows, has clear boundaries, and that they know what your role is and what their role is, and that they're not going to be perhaps reinterpreting your legal advice later on to the client. So you need to make that clear to them at the beginning. The second skill in relation to interacting with clients, interviewing clients, is just general rapport building skills. So I always like to ask some ice-breaking questions, talking about, did you have trouble getting here, or talking about the weather, or any of those types of ordinary things, because a lot of clients haven't seen a lawyer before. Going to an office, a lawyer's office, can be really nerve-wracking, and that's sometimes part of what's nerve-wracking about the entire thing is not just the legal proceedings, but it's meeting a lawyer for the first time. So again, that's that general bedside manner equivalent. You might need to practice those skills. Some other things to think about when you're interviewing the client is setting up the room and making sure that for some clients, they might want to see that there's an exit that they can use if they're feeling panicked. And so you might also want to look after yourself and make sure that you can exit if things were to get heated. So making sure that both parties have a clear way to get out of the office. Part two, when taking instructions from clients, just have a think about what language you're using. You want to avoid judgmental language, like asking the client, oh, well, why didn't you leave? Or why did you let him do that? And I try and avoid passive language, so where you might say a chair was thrown. We know that if it's the other party that threw the chair, then say it how it is. That's putting the accountability back on the perpetrator for those types of matters. I think it's important as well for when you're interviewing clients who are victim survivors of domestic violence, who will often have trauma, and where trauma-informed lawyering will often come into play. It's important to explain to them and acknowledge to them that there is a bit of a gap between we see in the media that that domestic violence is something that's been spoken about more and people are understanding about it more, but also the law hasn't really caught up to that in some aspects. And for example, you might have, we understand that coercion and control or financial abuse or psychological abuse are still very much examples of abuse and domestic violence. However, it's often in the court system that the court is looking for things that are at the more serious end in terms of physical violence. And so you'll often have to ask the client to, if you're making an application for a restraining order, perhaps, you will often ask the client about, tell me some times when there's been physical violence. So acknowledging to the client that unfortunately there is that gap there. Another important skill when you're taking instructions is active listening. So making sure that you really are taking the time to listen to the client and you don't have other distractions, and you've set aside a appropriate period of time, because a lot of these traumatized clients they're not going to approach instructions chronologically. They're going to be highly stressed. The trauma impacts on the way that they can remember things. And so you need to be able to take that time to sit there and listen to the story, and it might not flow in the exact way that you would like it to flow chronologically for your purposes of how you need that information to appear eventually in an affidavit or in an application, whatever you're getting the instructions for. So some other general active listening skills are things like repeating back to the client. So I'm hearing that you're saying X, or tell me if I'm right when I'm saying Y. We do know that clients really value it when they feel that the lawyer has listened to them and understood them. And we know that a lot of the complaints to the Legal Practice Board are about a lack of communication between lawyers and clients. Again, when I'm taking instructions, I will also try, and if I've had that support work and I'm able to have got some information from them beforehand, or I have some other way of getting some information beforehand, then I will try and have that information so I can say to the client, my understanding is this is what's happened, and set that all out. Do I have that correct? Have I understood that? Is there anything that I'm missing? And then the client, again, you're avoiding having to make them tell the story again. You often have clients who are coming into the office that are highly anxious and they're presenting very stressed out. You might have a general way that you would approach an interview. You need to be flexible in that process. And I will often ask the client, look, I'm noticing that you're seeming quite anxious about something. Is there something, what's worrying you the most about this whole issue? And then see if you could potentially give them advice on that first, or address that issue first, so that then they can relax and concentrate on the rest of your advice. For the third part, so in terms of giving advice and managing client expectations, there are a few tips for that. Firstly, don't overwhelm clients with a lot of information. A lot of clients will have multiple legal issues. They might have restraining order matters at the same time as family court matters. They could have criminal law matters going on all at once. So you might need to have multiple interviews, meet them multiple times to be able to address each of those separate areas. When I'm giving advice, I also, at the end of the advice session, will always ask the client, does that make sense? Do you have any questions about anything in particular? Sometimes you might even say, do you want to explain back to me what you think your options are, just to make sure that the client has understood. Something that I find really useful is drawing diagrams for clients. So I'll often pull out a piece of paper and say, look, these are the options, and I'll put number 1, number 2, number 3, and then I'll draw pathways off those options so that I can visually represent how a matter might play out. And you can then take a copy of that for your notes, and you can give the client a copy of it, and they can walk away with it and have a look at that later on. It's important to be able to manage the client's expectations during an interview. Like I said before, ideally you would be able to have put aside quite a significant amount of time to be able to deal with a client who you anticipate is going to be impacted by trauma. If you can't, however, though, then you need to be upfront with that and say, look, I only have X amount of time because I have another appointment afterwards, or I have a court appearance afterwards. I really want to hear the story from you, but I only have time to be able to get this portion of the story, or I only have time to give you advice on this, or I only need instructions about this particular matter moving forward. So be upfront that that's exactly what you want from the beginning, rather than a client having a false expectation that you're going to be listening to an entire history of events, and then you're jumping in and interrupting them and making them feel not heard. When you are interviewing a client and it is the case that they are looking overwhelmed, it might be that you need to take a break, or ask them, do you need to take a break? And so again, that comes back into when you're deciding what kind of time to set aside to interview that client. You may need to factor that in, that this client might need breaks because it could be quite a traumatic experience for them. I think it's important to also manage the client's expectations about the entire legal process in general, and to not set them up to fail, and to give them realistic expectations. So really reality checking them about how things may play out. It's important to be able to recognize emotional triggers and to say to a client, look, I need to ask you some questions in particular that might be traumatic for you or stressful for you to have to retell, but I have to ask you anyway. So at least giving them an idea that you're about to do it. Or you might say, I need to know, I'm aware that there was a time when you were hospitalized. I know it's not pleasant to talk about, but I do need to specifically ask you some questions about that, so you're not just jumping straight into it. And then you need to be ready for an emotional response. Could be crying, there could be a panic attack, there could be more general anxiety, there could be anger. You need to be aware that those things are potentially going to arise, and perhaps have thought about how you're going to handle that when they do. Trauma and emotions can impact on people's recall. So as lawyers, we often want a chronology of events, but that might be difficult for some people to be able to produce for you. And in those circumstances, we just have to go for more general timeframes. So we might need to have a more general approach where we're using language like on or around January last year, or towards the beginning of last year. It's also important when you're giving advice to clients that you're aware of various therapeutic options or non-litigation models. So things like mediation and shuttle conferencing for restraining order matters, or other ways to resolve things that would be less traumatic for the client. Finally, a trauma-informed lawyer also needs to be informed about their own trauma that may arise and their own self-care. So, of course, encouraging people to use services like their EAP or a debriefing with other colleagues or supervisors, but also knowing when to draw the line with a particular matter or a client. If you have a client that the relationship is broken down and you find yourself every time you have any dealings with that client that you're feeling very anxious or stressed out, or you're feeling too emotionally attached to the client, then you risk burning out. And so you might want to look at seeing whether that client could be reallocated, or perhaps seeking some assistance about how you might approach that and deal with that better.